So we're also recording this one. We're trying to break it up so it's not one long file for folks that need to watch it. But our next speaker is Mae Johnson, who is the administrator for the Agricultural Conflict Resolution Service, which is a part of MDA. I will let Mae talk a little bit more about what she does and some of the services they provide and how they can help with ag leases. But Mae, it is all yours.
Good evening, everyone. Thank you, Paul, for hosting this workshop. Did just want to just mention that the Agricultural Conflict Resolution Service is a part of the Maryland Department of Agriculture, and it is a free or low-cost service to all producers or those engaged in agriculture. My contact information is on that page. So next slide, Paul.
Oh, Mae, if you will just click on this arrow down at the bottom that says next on
Okay.
your side,
Okay.
and it will go for you.
There you go. Okay, thank you. Well, just a little bit of background about mediation and also about leasing. In the past several years, we have had a number of conflicts related to leasing because those leases have historically been word of mouth leases. The challenge has been that as people inherit the land from their parents or other relatives, they're not familiar with the terms of the word of mouth lease, and they don't understand the protections that farmers may have with regard to a lease. So the University of Maryland has prepared a guideline that incorporates mediation into the lease. Mediation is a tool to help resolve conflict. I'm going to talk a little bit more about that later. The goals and objectives of today are to make you aware of mediation as an opportunity to resolve disputes, to encourage the use of mediation, to encourage participation through incorporation of mediation clause within leases. I'd like to say that most companies have lease clauses in their contracts, whether they're doctors, hospitals, employers, credit card companies, and some government agencies ask that you sign an agreement that says that you will mediate your conflict before you take additional action, whether it be court or any appeal process. We also want to encourage the participants, and that would be you, to share information with farmers about the opportunity to mediate, because it provides a great opportunity for improving relationships and resolving problems, helping people to understand themselves. In Maryland, we have a two-part mediation program. The first part of that program is a certified program that's funded by the federal government. They provide us with matching funds, and they provide us with those funds to mediate any type of conflicts between the U.S. Department of Agriculture agencies, such as Farm Service Agency, Natural Resource and Conservation Service, Rural Development, and also creditors, which includes banks and farm credit organizations. The second part of our program is funded by the state of Maryland through the Department of Agriculture to assist in resolving right to farm issues. And those right to farm issues typically are neighbor to neighbor type issues. And we're going to talk a little bit more about those in detail. The first part of our program is the USDA Certified State Mediation Program. We're talking primarily about the Certified State Mediation Program because sometimes leases become a part of agreements that you sign with U.S. Department of Agriculture agencies. But if you're borrowing a loan and you have a lease, you're going to have to show that that is a good lease. Leasing is considered a credit issue, and so it is covered by the first part of the mediation program, which is the USDA Certified State Mediation Program. In addition, landlord and tenants, the credit mediation can be held between borrowers lenders, banks, businesses, agricultural supply stores, and anyone else that the farmer or agricultural producer has a credit relationship with. We are primarily focusing tonight on including mediation within the lease. The University of Maryland's sample language is all claims and disputes arising under or relating to this lease are to be first submitted for agricultural mediation through the Maryland Agricultural Conflict Resolution Service. If any or both parties shall equally share the mediator's costs and fees, this provision may be enforced by any court of competent jurisdiction, and the party seeking enforcement may seek all costs, fees, and expenses associated with enforcing this provision. If you include the mediation clause in your lease, that then is binding, and the leaseor or the tenant is required to participate in the lease process. So that is something that is a protection for both parties because it gives both parties the opportunity to resolve their issues without going to court or without pursuing a particular hearing. There are some benefits to the mediation process. It's a neutral process. We assign a mediator, and that mediator has no interest in the outcome. They are just simply there to help the participants come to an agreement that they can live with. And I say that they can live with because sometimes you may not be able to resolve everything, but you can agree on what can be done and what is acceptable to both parties. The agreement is confidential, and that means that the parties agree that they won't discuss it with anyone outside of the mediation, and it won't be used against either party in any legal action. The time and the cost are efficient. The process is quicker than going to court. It's quicker than any type of appeals process at the local county level. And generally, our mediation in Maryland does not cost anything. So therefore, of course, it's more efficient than the litigation or the arbitration process, which can be very, very expensive. And it also can be very, very timely. It is what we call self-determination. The mediator, although they are present to help you discuss your options and come to an agreement, they do not make a decision for you. Their goal is to make sure that you can live with the agreement. And so the parties involved in the mediation, in this particular case, the leasee or the leaseor, come up with their own solutions. This protects the relationships and it creates an understanding. Most people want to be respected and they want to be heard, even though there may not be a solution that comes out of the mediation. Sometimes it does improve the working relationship between the parties. We also want to be sure that as a result of the mediation, there's an understanding of what's going on. So we want to talk a little bit about understanding conflicts. Conflicts in terms of agriculture, as in any other activity, tend to emerge from routine circumstances. People think they heard or understood what you meant. I want to just share just a little story about a young couple on their honeymoon. They'd gone to a nice, beautiful island, and the natives told them, don't get in those waters. There are devils in the waters. Well, as soon as they could, the couple got into the beautiful blue waters and they became very, very ill. While they didn't understand there's devils in them their waters, then certainly the communication was that getting in that water would cause you a problem. During the mediation process, the goal of the mediation too is to make sure that expectations are clearly defined. when expectations are not clearly defined, they do cause problems. We had a mediation request at one point where a person had indeed signed a lease. It was a residential lease. The land was owned by a daughter who had inherited the land from the father. She signed the lease. The farmer began to plant. She became very, very upset because she thought that the farmer understood that she wanted her farm area to be organic. She didn't understand that necessarily that becoming organic takes some time. And so it would have been more effective had the initial lease discussed those things that impact have different values for how they want to use their land and what their expectations are. Of farmers who may be renting their land. Uh, the property itself may change. The property may be impacted by taxes, government programs that restrict what you can do. So there are a variety of things that need to be understood when addressing conflict. In Maryland, as in other places, we have had some common types of conflict. And those conflicts have reflected use of property issues. And I just mentioned the person who thought that the land was going to be immediately organic. The term of use, how long will the land be used? That has to be explained. The use of the land itself, what types of crops are going to be planted. Payment of the rent. When is the rent due? If you are renting the land and you decide, well, okay, I won't ask the farmer to pay me for a period of time, then is that an oral contract? Or should you pursue the payment of the rent? So complaints from neighbors about tenants. There are neighbors who tend to call landowners to let them know what's happening on their land and whether or not they are caring for the land. So all of that should be incorporated into the lease so that the person is prepared to deal with what is going on when they are the renter. They should know what to expect from the landowner. Okay, pause.